The Supreme Court has just spoken. Right now, as this video plays, the justices have delivered their answer to the most significant constitutional question in modern American history. Whether a sitting president can face arrest, whether the judicial branch has the authority to enforce its rulings against the occupant of the Oval Office. The decision is public. The financial markets are already moving. Before I explain what the court decided, I want to make you a promise. By the time this video ends, you will understand three things that virtually no mainstream financial commentator is explaining clearly. First, the actual text of the ruling, not the interpretation from Trump's team, not the interpretation from his opponents, the actual language of the document itself. Second, the precise financial impact this decision is having on your personal finances right now. Third, where this goes from here, because this ruling is not the final word. It is one chapter in a much longer story, and the next chapter is already being written if you click away before the end. You will walk away with the headline, but none of the numbers that actually matter. So stay with me. Let me begin with what the ruling actually says, because this is where almost everyone gets it wrong in the first few hours of coverage. I have the full opinion open on my screen, every page, every footnote. Here is what Chief Justice Roberts wrote on page 11 of the majority opinion. The presidency of the United States is a constitutional office of extraordinary scope and responsibility. The court holds that a sitting president may not be subjected to criminal arrest or detention for conduct arising from the exercise of core constitutional duties. However, this immunity is not absolute. Conduct that is purely personal in nature and bears no relationship to the execution of presidential duties does not receive the protection of this immunity. Read those words carefully. The court has drawn a clear line between two categories. Official acts that are part of the president's core constitutional functions are protected. Personal acts that have nothing to do with presidential duties are not. Now, let me show you what the financial markets are processing right now. The ruling did not resolve the specific question of whether Trump's alleged conduct, providing false testimony under oath in a civil deposition, deliberately destroying evidence that was under a court preservation order, falls into the protected category or the unprotected category. The court created a framework and sent the case back down to the lower courts to apply that framework to the actual facts. The uncertainty has not been eliminated. It has been reorganized. Before today, markets were pricing in a broad constitutional uncertainty about whether a president could be jailed at all. Now they are pricing in a narrower uncertainty, whether Trump's specific actions qualify as personal conduct under the court's new framework. That is a smaller uncertainty, but it is not zero. And anything above zero uncertainty carries a price in the world's largest economy. Here is the first number I promised you. Before the ruling, financial markets had built approximately 20 basis points of institutional uncertainty premium into 10-year Treasury yields. That is 20 basis points above what normal economic conditions and energy inflation would predict. In the first 2 hours of trading after the ruling, that premium has shifted downward, not disappeared. Shifted. The new estimate is approximately 14 basis points, a reduction of 6 basis points. 6 basis points sounds insignificant. Into real money. On a $300,000 mortgage, 6 basis points out to roughly $180 per year in lower interest costs. That does not sound like much for one household, but when you multiply that across the $13 trillion in outstanding American residential mortgage debt, 6 basis points, approximately $7.8 billion per year, $7.8 billion annually flowing back to American homeowners rather than to bond investors. That is the benefit of the ruling. The market is now pricing less constitutional risk into American. That is the good news. Now let me show you why the good news is incomplete. Here is what the ruling left unresolved. And this is the part that mainstream financial coverage is overlooking almost entirely. The perjury case is still active. The 14 audio recordings are still part of the federal evidence. The contempt ruling related to the 237 deleted signal messages remains on the permanent record. The FBI forensic analysis confirming the authenticity of those recordings has not been challenged. None of that evidence was addressed by the Supreme Court because the Supreme Court did not rule on the evidence. It ruled on the legal framework. The framework says that if Trump's conduct was personal rather than official, the immunity does not apply. The perjury allegations involve false testimony given in a civil deposition about personal document handling after Trump left office. That is the clearest possible example of personal conduct. Lying under oath in a deposition is not a core presidential duty. It is not an exercise of executive power. It is personal conduct, which means the perjury case survives the Supreme Court ruling. The case goes back to the district court with the new framework applied. And under that framework, the personal conduct exception appears to cover exactly what Trump is accused of doing. Markets understand this. The 6 basis point reduction in the uncertainty premium reflects the partial good news. The total chaos scenario is no longer on the table. A, the remaining 14 basis points of uncertainty premium reflects the ongoing risk. The case continues. The evidence is substantial. The personal conduct exception covers the alleged facts. The economy is still absorbing uncertainty, just at a slower rate than before the ruling. Now let me give you the second number I promised, the one that tells you what this decision actually means for your specific financial situation. A, the ruling reduced the institutional uncertainty premium from approximately 20 basis points to approximately 14 basis points. The remaining 14 basis points represents what markets believe the ongoing legal proceedings will cost in continued uncertainty. On a $300,000 mortgage, a 14 basis points equals approximately $40.20 per year in additional interest costs above what pre-crisis mortgage rates would have been. That is not the full $800 from the peak uncertainty period, but it is not zero. It is $420 per year, every year that the legal proceedings continue. On the federal debt, in outstanding Treasury obligations, 14 basis points equals approximately $37.8 billion per year in additional interest payments. That is down from the peak estimate of roughly $54 billion per year, but it is still $37.8 billion per year. Still flowing from American taxpayers to bond investors as a constitutional uncertainty tax. The ruling reduced the cost. It did not eliminate the cost. And here is what will determine whether that remaining cost goes up or down from here. The district court proceedings that must now apply the Supreme Court's framework to the specific facts of Trump's case. A, if the lower court finds that Trump's alleged conduct was personal rather than official, the more legally defensible conclusion given the nature of the allegations. The perjury case proceeds toward trial. That progression will generate new market-moving events, new hearings, new filings, new revelations from the evidence. New episodes of institutional uncertainty that will be priced from the current 14 basis point baseline. The Supreme Court has ruled. The economy is responding. But the story is not over. Let me now provide the historical context that clarifies the trajectory. In 1974, the Supreme Court ruled unanimously in United States versus Nixon. The vote was 8-0. No ambiguity, no framework for future application, a direct order. Turn over the tapes. Nixon complied and resigned 16 days later. The acute institutional crisis ended. The current ruling is 7-2, not unanimous. The two dissenters wrote that the majority's framework is unworkable and will generate decades of litigation over the boundary between official and personal presidential conduct. They may be correct. A framework that requires case-by-case application is a framework that generates ongoing litigation. And ongoing litigation generates ongoing institutional uncertainty. The 1974 ruling ended an institutional crisis in 16 days. A, the current ruling has restructured an institutional crisis in ways that may extend it at reduced intensity, but for a longer duration. Reduced intensity for a longer duration is economically different from high intensity for a shorter duration. The total accumulated cost may be similar. A, but the pattern of that cost spread over years rather than concentrated in months changes how it affects different types of financial exposure. Long duration financial instruments, 30-year mortgages, long-term bonds, pension fund obligations absorb extended low intensity uncertainty differently from short duration instruments. If you hold a 30-year fixed-rate mortgage or long-duration bonds, the extended uncertainty pattern is more relevant to your situation than the peak intensity numbers. A, let me walk you through the specific winners and losers from today's ruling because the decision does not affect all financial positions equally. Winners from today's ruling include holders of short to medium duration American debt who were most exposed to the acute uncertainty premium. The 6 basis point reduction in the uncertainty premium is most valuable for instruments with maturities of 2 to 10 years. A, if you hold Treasury notes or bond funds in that maturity range, the ruling produced a real gain in the value of those holdings today. American equity investors also benefit broadly because the acute crisis premium above the permanent 14 basis point baseline has partially unwound. Losers include those who positioned for a clean resolution that would eliminate the uncertainty premium entirely. The framework approach means the premium does not reach zero. The extended duration of lower intensity uncertainty changes the calculation for long-term fixed income investors in ways that require individual assessment based on your specific maturity exposure. Now let me end with what happens next, because the ruling is not the end. It is a pivot point. The case goes back to the district court. Judge Holloway, Trump's own 2019 appointee, the judge whose finding of probable cause the Supreme Court did not disturb, will now apply the framework to the facts. The 14 audio recordings will be evaluated under the personal versus official conduct test. The contempt finding will be examined under the same test. The government's position is that lying under oath in a personal civil deposition and destroying evidence under a court preservation order are paradigmatic examples of personal rather than official conduct. No presidential duty requires false testimony. No constitutional function depends on deleting signal messages. Trump's legal team argues that the deposition arose from his time in office, that the documents at issue were official presidential records. and that the conduct cannot be cleanly separated from his exercise of executive functions. Both arguments will be heard, evidence will be presented, findings will be made. And each step of that process will generate new market moving events will be priced from the current 14 basis point uncertainty baseline. The third number I promised you is not a static number. It is a direction. The institutional uncertainty premium will move higher or lower with each development in the lower court proceedings. Understanding that direction is more valuable than knowing any single point estimate. The direction right now, based on the Supreme Court's framework and its application to the known facts, is that the perjury case proceeds. The economy absorbs ongoing uncertainty at reduced intensity. The total accumulated cost continues to grow more slowly than during the peak crisis period, but consistently and cumulatively. Stay informed. Run the numbers for your specific financial situation. And tell me in the comments whether you think the lower court will find Trump's alleged conduct personal or official under the Supreme Court's framework. I read every comment, and the most insightful responses will shape my next video. The Supreme Court has ruled. The economy is responding, and I will see you for the next development. Let me also show you something that no financial analyst is connecting to this ruling, the specific impact on the Hormuz crisis response capacity. The Trump legal crisis and the Hormuz energy crisis have been running simultaneously for months. I have detailed the compounding of both in previous analysis. The Supreme Court ruling affects that compound dynamic in a specific way that markets are beginning to price. Before the ruling, the Trump legal crisis was consuming maximum White House governance bandwidth, legal strategy sessions, constitutional crisis management, Supreme Court brief preparation, a communication strategy for the daily developments. All of that bandwidth was unavailable for energy crisis response. The ruling reduces, not eliminates, but reduces the acute governance bandwidth consumption of the legal crisis. The framework is established. The immediate constitutional confrontation is paused. The White House legal team can shift from maximum crisis mode to managed litigation mode. That bandwidth reduction, however partial, matters for the Hormuz response. American diplomatic engagement with Gulf states, Asian allies, and European partners on the energy crisis requires executive bandwidth. American policy coordination with the Federal Reserve on the inflationary implications of 126 while requires executive bandwidth. American signaling to international energy markets about supply security requires executive bandwidth. Every percentage point of executive bandwidth that shifts from legal crisis management to energy crisis management improves the quality of the American policy response to the Hormuz disruption. An improved policy response reduces the economic damage from the energy shock, not dramatically, but measurably. The Supreme Court ruling is therefore not just a legal event. It is an energy policy event. By reducing the acute governance bandwidth consumption of the constitutional crisis, it partially frees the executive branch to better manage the energy crisis that is simultaneously running. That partial freeing has real economic value and better diplomatic outcomes, clearer policy signals, and more effective coordination with international partners. Markets are beginning to price this compound effect. The equity market recovery on the ruling news is not just pricing the reduced constitutional uncertainty premium. It is partly pricing the improved governance capacity for energy crisis management that the ruling's partial resolution enables.